Hi, I'm Ed Cross. I'm a California lawyer and I represent restoration contractors and industrial hygienists. One area of law that is particularly problematic for the restoration industry is the procedure for mechanics liens. It's one of the most complex areas of law that affect the industry. Mechanics liens are powerful tools, but they're controlled by strict rules, and procedural errors are very common. The most common error is late filing, but we also see many errors in the identification of the property, the calculation of the balance due, or the statement of the date the payment was due. The constitutions of many states give workers the right to a mechanics lien for the value of labor and materials provided for the improvement of real property, and they authorize the legislatures to provide for the speedy and efficient enforcement of these liens. However, property owners have complained that until they receive the foreclosure lawsuit, they are often entirely unaware that a mechanics lien has ever been recorded on their property. To combat this problem, California has enacted a strict new law that took effect on January 1st, 2011, and that establishes a notice of mechanics lien, which must be served together with the lien. Among other things, the notice states that the property is subject to legal action seeking a court-ordered foreclosure, that the legal action may affect the owner's ability to borrow against or sell the property, and that the owner should contact the contractor or an attorney immediately. The language of the notice is established by statute and must be quoted verbatim. The new law also requires the contractor to execute an affidavit under penalty of perjury, stating that a copy of the lien has been served on the owner. The affidavit is called a proof of service. It's executed by the person making the service, showing the date, place, and manner of service, and the facts showing that the service was made in accordance with the new law. The affidavit must show the name and address of the person upon whom a copy of the mechanics lien and notice of the lien was served, and if appropriate, the title or capacity in which he or she was served. Some restoration contractors have asked me if the service requirement means that the lien and notice must be personally served. I'm pleased to report that the answer is no. Service by mail on the owner is sufficient, but the notice must be served together with the proof of service, and failure to follow these rules causes the lien to be unenforceable. Fortunately, the process is not elaborate, and a proof of service is a simple form which we can provide you. Once you do a few, it'll be easy. Mechanics liens are an important tool for you and your business because they help to secure payment. They must be filled out with great attention to detail. If accurate information is unknown or not readily available, it'll be necessary to undertake an investigation to discover the correct information. Before you submit a lien to the recorder's office, it should be double-checked for accuracy and proofread. Simple mistakes, such as spelling errors, can lead to significant problems, may make the lien unenforceable, and can lead to costly litigation. You have 90 days from the date of substantial completion to record liens in California. But calculating the deadline can be sort of tricky, so save yourself the headache and simply record your liens early to avoid any argument. 45 days is a good rule of thumb. This will also help avoid overlooking errors in the last-minute rush to the recorder's office. If you find an error in your lien after it's recorded, call your attorney right away. Certain errors can be corrected if detected early. The new mechanics lien law will be repealed on July 1st, 2012, and it remains to be seen what will happen after that. But we will continue to update you in the Restoration Lawyer newsletters. Feel free to contact us if you'd like help with your liens or your collections. We provide a broad array of legal services to the restoration industry. Thank you.